The concept of the international law was first marked by the British philosopher Bentham. International law is the body of rules, treaties, and norms that are applied between the independent states and also the binding force between the sovereign states and are recognized by the international forum members. International law is also known as the law of the nations. To Bentham, international law is a collection of rules governing the relation between the states. The primary sources of the international law are treaties, conventions, agreements, declarations, and international customs. Apart from the primary sources, the secondary sources are judicial decisions and juristic writings and teachings. Beside it, there are various other factors that are responsible for the development of the international law, such as UN Security Council declarations, recommendation of the UN General Assembly, and international morality and equality. Article 38 of the International Court of Justice Statute recognizes customs, treaties, and general principles are the primary sources of the international law. In international law, the sovereign countries are called states or nation state, and the member of the international community are known as the member states. For the proper functioning of the international law and relations between the nation states, various international organizations have emerged. For the proper functioning of the international organizations, the essential ingredients that we found are stable and permanent organs for the proper functioning. 2. Multilateral international agreements. 3. Independent identity of organs. The development of the international organizations started during the early 19th century, during the Congress of Vienna, and developed in a systematic manner. Previously, the League of Nations was established to maintain the relationship between the nation states in low key matters. The League of Nations stops its operation on 20th April 1946 after the World War II, and the United Nations was established on 24th October 1945. India was the member of the League of Nations and the founding member of the UNO. International law can be divided or classified under three heads. 1. Public international law. 2. Private international law. And 3. Supranational law. Public international law deals with the nation states, but the private international law deals with the citizens of different nations. In today's world, citizens of a country are interacting with the citizens of the other nations and falling in legal relationship either through trade and business, education, or marriage. In case of the conflicts between the two or more citizens of the different nations, international law comes into play. The term supranational meaning transcending national boundaries, authority, or interest. The supranational law is different from the public international law. Supranational law is a form of international law subject to the limitation of right of the member states between one another, such as European Union. The objective behind the international law is to promote, develop in both sphere economic and human values, security, peace, and harmony between the nation states, resolve the international conflicts or dispute, including boundaries, prevent terrorism, promote justice, and many more. The branches of the international law can be separated in two heads. 1. Jus gentium. 2. Jus inter gentis. The question always arises in the mind of a law student that can we say international law as law in the strict sense? Two sets of jurists had opined that thought. Firstly, the Australian school, headed by Austin and Hall, viewed international law cannot be regarded as law. They forwarded the following arguments. 1. Sovereign state. In the present world, every state is independent and sovereign, both internally and externally. There are no authority that can restrict them from doing so. The international bindings are mere prescriptions, not law in strict sense. 2. Command of the sovereign. The analytical school described law as the command of the sovereign authority. But in the international arena, all nation states are sovereign and there is no master sovereign authority to command the state. So without world state, there is no international law. 3. Punishment. To Australian school, people obey law because they fear of physical punishment. In case of the international law, there is no such scope. Obedience to the international law depends on the diplomatic and moral standard of the nation state. 4. International morality. Particularly, the purpose of the international law is to maintain peace and security and to stop war. These laws are usually overlooked by the state having immense power, but in majority, it is followed on the moral ground. So rather than international law, it may be called international morality. 5. Judicial organ. The laws of the nation state are interpreted by the highest judicial organ or court. But in the international arena, there are special tribunals. But states are not bound to act in accordance to their dictums. Dear viewers, I request you to watch the video on various schools of jurisprudence. The link is given in the description box. Also, I have suggested few videos for you to learn with me the basics of law. Hope you will enjoy. Other set of jurists vehemently criticize the view of the analytical school. To them, international law is the correct law. They forwarded their arguments. 1. National law. International law are based on customs, usage and rules which every independent state have to follow and insert in their respective municipal law. In global arena, there are set of international rules of conduct which are binding upon the states. Lastly opined, municipal law in a word should be legally subordinate to international law. 2. Sanctions. Analytical school of thought has been criticized here. If a state goes against the law, rules, order and norms of the international law, the UN can put sanctions against the state in economic, trade and commerce and others. Here, physical force may not be applied, but the moral force uses in form of sanction. 3. Enacting law. The international law has been recognized by the independent state in the matter of enacting any laws. While enacting laws, legislatures take into account of the principle of international law and see that municipal law does not go against the principle of international law. 4. Court. The International Court of Justice is the judicial organ of the UN and have the power to resolve the conflict between the nation states as to the principle of the justice and international law. If we reconcile the views of the two set of jurists and come into the practical position, it will be bit confusing. Strictly, international law cannot be recognized as law, rather moral standards. There is no determinate sovereign authority in the international sphere which can compel the state, not even the UN. So it is correctly said that international law is half law and half morality. So we can conclude international law is the vanishing point of jurisprudence.